On May 8, 2023, Corey Richens was indicted by a Summit County, Utah grand jury on multiple counts, including aggravated murder, attempted murder, and financial fraud crimes in connection with the death of her husband, Eric Richens. The indictment followed an investigation into the March 2022 events in Kamaz, Utah, where Mr. Richens died from a lethal oral overdose of fentanyl inside the family home. According to the investigation, the couple's marriage had been heavily fractured by profound financial disputes and illicit drug purchases. Following his death, Eric's personal representative instituted a civil wrongful death action against Corey Richens, seeking damages in excess of $10 million and alleging a premeditated financial motive behind the alleged poisoning. The criminal case was heard in Utah's 3rd Judicial District Court before Judge Richard Mrazek, roughly 4 years after the homicide occurred. Following extensive pretrial litigation, the high-profile jury trial officially commenced in early March 2026. On March 9, 2026, private investigator Todd Gabler was called by the prosecution. Mr. Gabler was conducting a private civil investigation focused on protecting assets, locating real property, and conducting forensic financial audits. He had been hired immediately after Eric's death by the personal representative of the Eric Richens family estate and their counsel. The family sought his services because they suspected that Eric's sudden death was the result of foul play rather than accidental causes, and they needed to investigate the couple's profound financial disputes and Ms. Richens' crushing business debts. Upon the conclusion of direct examination by Chief Prosecutor Brad Bloodworth, defense attorney Catherine Nestor conducted cross-examination of Mr. Gabler regarding the scope of his investigation.
I want to just kind of start with a basic observation, but just to make it crystal clear. You are not law enforcement, correct?
Correct.
And you've never been law enforcement in your whole life, right?
Correct.
Okay. And the rules and ethics and expected practices of private investigators are significantly different, would you agree with me, than those that apply to licensed law enforcement?
I don't know that I would agree with that in every circumstance. A private investigator, when he is hired by a lawyer, is bound to all the ethics that that lawyer is bound to.
Okay.
So,
but for example, you don't have to go get a warrant to go look at a house.
well, right, that's the state action distinction.
Right.
Yeah.
Right.
I'm not a state actor.
Right.
I've never been a state actor.
Right.
I will never be a state actor.
Right.
Yeah.
So if you want to go search a house for 6 straight days and look at thousands of documents, you don't need to get a judge to give you permission to do that, right?
No, I got the permission of Corey's lawyers who represented her to do that.
And you also got the permission of Clint Benson, right?
Yes.
And in fact, Clint gave you a key.
Yes.
And you had that key to use at your discretion.
Yes.
And there were times when you would go to the house and Clint was not there and you would let yourself in, right?
I believe that my testimony covered that, and that was that Clint was aware that I was there and he was either on his way or there with me.
But you agree with me, and you have videos, I believe, that back this up, that there were occasions where you would go to the house, Clint was not there, you'd use your key, and you'd go in.
Yes.
And there were occasions where you would be spending hours and hours and hours in the office, because I've
Yes.
watched all the videos,
Yes.
and you would be there alone without Clint anywhere around you.
Yeah, I don't need supervision, counselor.
Perfect.
I was conducting an investigation, independent investigation, and he had given me the key, trusted me with that, and I was authorized to enter the premises at will.
Right. So if he got on the stand and said you were never doing anything outside his eye, that would be false.
Well, from his perspective, he had knowledge of my presence there, as I have testified every time I was there.
Fair.
So from his perspective, it may look different.
But you agree with me, sir, that there's hours and hours and hours of video of you alone in that office going through things.
I think that I've already testified to that.
Okay. Now, you were not permitted access to the house until after Corey had been arrested, right?
No, that's not correct.
You got in the house before she was arrested?
No, that is not correct.
Okay, help me out.
The house was released by the Summit County Sheriffs on the 8th.
Of
That's
May?
what gave us, that was the trigger, not Corey's arrest. It was the end of their search that triggered our access to the house.
Okay.
The police were executing a warrant.
Do you know when Corey was arrested, sir?
I don't recall the exact date or
Would it-
time.
Would it surprise you to be the day before May 7th?
Okay.
All right. So,
Objection, Your Honor, foundation on that.
Was
Would
it
you
May 8th?
re-ask the question, Ms. Nestor?
It was May 8th.
sorry, would it surprise you if it was the same day, May 8th, that you got access to the house?
It would not surprise me since I do not recall.
Okay. And during the time after Eric's death, but before Corey's arrest on May 8th, did you ever go inside the house for that entire year?
I'm sorry, could you ask that again?
Sure. During the time between when Eric Richens died on March the 4th,
Yep.
in the early morning hours
Yep.
of 2022,
Yep.
and May 8th of 2023, were you ever inside the house at any point in between those times?
No, never.
Perfect. So the first time you ever got into that house, over a year had expired since Eric had passed.
Yes.
Okay. And you mentioned the police had executed a search that day before they released it to you, right?
Yes.
And do you know how many times prior to that the police had searched that house?
No.
Okay. And then you've also testified here, I think very honestly, that on repeated occasions you notified the police, hey, there's something you missed. You might want to go back to the house and find it again.
I mean, I'm not going to adopt your characterization, but it is true that I called them back to that house when I discovered something that I thought was evidentiary.
How many
Important.
times?
Oh, I don't know, 4, 5.
So on at least 4 to 5 occasions,
Yeah.
you found things the police had missed.
Yeah, oh, that's been my experience throughout my career.
And you
The
told
police
them,
never
sorry.
get everything, ever.
Right. Well,
It's
not going to
true
argue.
in
with-
every case I've ever handled.
Sure, not going to argue with you on that one.
Yeah, it's true.
So they come back because you call them and say, hey, I found something, come back, here's where it is.
Yep.
And they know you're doing that. They know that you have full access to this house, right?
I don't know what they know. I
They-
can't answer that.
Well, you're calling them every time you find something.
Well, what opinion they formed in their mind is not within my knowledge.
Okay, fair. True, you called them every time you found something.
That I thought was of evidentiary value in their investigation.
And did
True.
any of them ever say, you know what, we're good, stop calling us?
No, I don't recall that at all.
So then the converse of that is they encourage you to keep doing that.
Well, no. That is not the converse of your hypothetical,
Okay.
and I do not agree with your assessment.
Okay? Did you feel like you were helping them?
I was following the instructions of my client to turn over anything I thought was relevant to the criminal investigation. This is not my case. My case is in the civil court. Anything that we thought was of value to the criminal case, we turned it over.
And the police were happy with that.
I don't know if they were happy or sad or distraught. I have no idea as to their emotional condition.
They sure never told you to stop.
The police never directed me to do anything, and if they had told me to stop, I would have ignored them.
Okay. So you could go in without a warrant, find something, call them, tell them to get a warrant, and they'd come get it.
I think that's an oversimplification and a vilification. I had permission to enter those premises. I had every right to be there. I didn't need a warrant. I'm not a state actor. I have the permission of the property owner. So I don't agree with your characterization.
When the cops would show up, did you point out what you were showing them? Were you usually there?
No, I was there on one occasion when the police showed up. They executed warrants when I was not there.
Okay.
Yeah.
Mr. Gabler explained that he had the authority to be on the property granted by the owners and Miss Rickens' attorneys, who permitted the search specifically because he was conducting an investigation into a civil case, not a criminal one. Because it was a civil matter, the defense team granted access to comply with standard civil discovery rules and avoid legal penalties for blocking the exchange of evidence. Under Rule 5.3 of the Utah Rules of Professional Conduct, a lawyer exercising direct supervisory authority over a non-lawyer assistant must make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the practitioner. Consequently, retaining counsel for Eric Richens' estate and family trust bore the ethical responsibility to oversee Mr. Gabler's investigative methods. Because an investigator retained by counsel must operate within the ethical guardrails governing the legal team, his actions are inextricably tied to Utah Rule of Professional Conduct 8.4, meaning the supervising attorneys could face disciplinary action for any ratified or uncorrected misconduct. Furthermore, because Mr. Gabler waited for the Summit County Sheriff's Office to fully process and release the crime scene before initiating his search inside the residence, his actions did not constitute spoliation of evidence or obstruction of justice.
Excuse me, I'm having difficulty keeping my head up.
Oh, no worries. Whatever you need, sir, to be comfortable. Yep, I'll go back to that. It's going to take her a minute to upload that, Your Honor, so we'll get to that. You don't recall putting electronics, documents in your Tesla and driving away from the house?
Oh, I remember that, yes. But that was not the C&E computer.
Okay, what computer was that?
I don't recall. I'd
So-
have to see the video.
So you
That's
were-
why I make them.
You removed a laptop from the office and put it in your Tesla and drove away with it?
I don't recall that, no. I do not. That would have been my, if there was a laptop in that office, it was mine.
Okay, well, we're going to pull it up in just a minute. I'll help
Fantastic.
refresh your memory.
Yeah.
Also, you mentioned earlier that you didn't take, other than the vital records and the attorney-client privileged records, that you didn't take anything else out of the home. That's not entirely true. You also took a safe out of the house?
Yeah, I described that by report, but that house, that safe was returned.
Okay, so you went into the house with your own key, correct?
Yes.
You went into the family, I believe is in the master closet, is that right? Where was it?
Yes.
You picked it up, took it out of the house, and put it in your Tesla.
Yes, I believe I did that at the request of Clint Benson.
Okay.
Yeah,
And then you drove it to a locksmith,
I did.
and you busted into the safe.
I did not bust into the safe.
Well, he did.
He bumped. He used a technique called bumping. It's the movement of the door and the frame of the safe that allows it to come open.
Okay, but you didn't have a combination.
I don't know if that was a combination. I thought there was a key to that one.
It was forced open with a hammer, right?
I think it was a rubber mallet, and it was dropped onto the ground.
Okay.
I think that's what eventually got it opened, was that it was dropped onto a flat surface.
And when you were doing that, there's no law enforcement there, correct?
I don't need law enforcement to babysit me.
Okay. And you open it up, and there's clips from guns in there, right?
I would have to go back to my report to recall exactly what was in there.
But you handled it with your bare hands, no gloves.
I did.
All right. And, I'm sorry. You also found an unusual residue in the safe. Do you recall that? That you touched with your fingers?
I don't recall that.
All right. We'll play that in a second.
Fantastic.
I do think we found the video of the laptop, so can we queue up for the witness only GXO10073?
Yeah, that's my laptop. I am scanning into my laptop the documents that I am going through at the office. That is my laptop.
The black one?
Yes.
Okay. So you're scanning all the documents you're finding in the office and then loading them into your laptop?
Yes.
Okay. All right. And again, Clint Benson was not present when you were doing any of this?
Yes, that is my testimony on direct.
Okay. Now let's go to the one of the safe. Can you pull up the clip 100055. Hold on just a moment. 1055. See if you can find that one. Sorry. I think it might be under the impeachment documents. Nope. Okay. All right, we'll get the safe one up to refresh your memory about that residue. You don't remember touching some residue and filming it and asking the safe breaker if that was unusual to find residue in a safe?
I don't recall that. I would have to refer back to the video that I made of that for just this purpose.
Okay.
Ms. Nestor questioned Mr. Gabler about the safe that he took out of the house, opened and touched the evidence without using gloves, and Mr. Glauber confirmed. This line of questioning directly leverages Utah Rule of Evidence 403, which permits the court to exclude relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusing the issues, or misleading the jury, alongside Utah Rule of Evidence 901, which mandates proper authentication to prove an item is precisely what the proponent claims it to be. By establishing that a private investigator drove the safe away in his personal car and had it opened by a locksmith without law enforcement supervision, the defense aims to demonstrate a fatal breach in the chain of custody, arguing that the state cannot guarantee the items weren't altered, substituted, or tampered with. However, Mr. Gabler confirmed that he did with the authorization of Clint Benson and also logged his actions in his investigative report. With that, the chain of custody protects Mr. Gabler by creating an irrefutable, authorized paper trail, even when standard forensic protocols are not strictly followed. By providing detailed contemporaneous reports of handling evidence, the investigator establishes authenticity under Rule 901 and proves a lack of bad faith, effectively countering arguments of tampering under Rule 403.
So my understanding is you were at the house. There were some times before you got access to the house while Ms. Richards was still living there that you would sit outside her house and observe the house while she was in it. Is that fair?
It is not fair. That is false.
You never did that?
I never sat outside her house and watched her. False.
Not on March 9th of 2023?
Correct.
Not on April 12th of 2023?
Correct.
Okay. But you did put trackers on their cars, is that right?
I did.
And that's a secret device that you put on someone's car so you can follow where they're going without their knowledge?
So GPS tracking devices are generally covert, and there's good reason for that. I put GPS devices on Corey's vehicle and two of Lisa's vehicles, one of which was being used by Corey's brother, Ronnie.
So her mother's cars and her car.
That is correct.
And how long did you track these individuals?
I think there were different times for different vehicles. I don't recall the exact amount of time, but that'll be in the file that you have.
And did you turn over your reports on every single place they went for months to law enforcement?
Yes.
And you know that law enforcement is required to have a warrant to do that.
Well, they have to get a warrant, and I have to go through a different procedure that's prescribed by Utah law to appropriately place those devices.
Did you track anybody else's car in this case?
I want to say yes. Yes, I did.
Who else's?
There were some vehicles that I suspected that Carmen Lauber may be utilizing. But I discovered that, in fact, the vehicle that was parked at her house overnight on many occasions was being driven by someone else.
So you never gave that report to law enforcement?
I believe I did.
You gave the Carmen Lauber tracking report to law enforcement?
Yes, it wouldn't be named Carmen Lauber, though.
What would it be named?
Oh. I want to say there were a number of people that were associated with her residence.
That's all right. If it's
There was
someone.
Nick Bonsavage. There was another young man who were frequenting that residence, and I believe that vehicle that I tracked from that residence was seen there overnight on multiple occasions.
Okay.
I really don't remember, because the point of that was to track Carmen Lauber. And when I discovered that it wasn't Carmen driving the car, I removed the device.
Okay. Law enforcement was also providing you, I believe you said that Mr. Bloodworth asked you if you got information from law enforcement, and you said no. Is that right?
No, that is not right.
Okay, please correct me.
Well, I would have discussions with law enforcement. I could garner an understanding. I could read between the lines, if you want.
In fact,
say
you
it
went
that way.
to meetings with law enforcement about this case, didn't you?
Oh, yes.
How many times did you have meetings with them?
I don't recall. I don't count them.
Okay.
The number is not relevant to me.
Well, you appreciate it might be relevant to me? Can you try to remember?
Half a dozen?
Ms. Nestor questioned Mr. Gabler about the GPS trackers he put in the cars to follow each person Mr. Gabler was investigating under the Federal Rules of Criminal Procedure. Rule 41, a magistrate judge may issue a tracking device warrant only if law enforcement presents an affidavit establishing probable cause that the electronic monitoring will reveal evidence of a crime. This requires the government to demonstrate a reasonable, factual belief that tracking the vehicle is necessary to the investigation, preventing arbitrary state surveillance. But since Mr. Gabler was investigating a civil case, he would not need a formal warrant. Under the Utah Code 76-12-305, a private investigator shall request confirmation from a state entity with access to updated protective order records and must ensure that the owner or lessee of the vehicle is not under the protection of a protective order or is related or living with someone in the same conditions of protective order. Once the state confirms the private investigator that those individuals are not in those patterns, the state can approve or deny their discernment. In this case, Mr. Gabler was cleared to use the GPS trackers.
You recalled seeing any texts with Eric about him and Corey having an open relationship, and you said you could not recall. Is that right?
Correct.
Can you put that up on the screen, Katie? Do you recall looking at that text?
I do.
You've seen this one?
I believe I have. It's a joke.
It's a joke.
It is. It appears to me to be a joke.
Did you see the text around this text?
I did.
So you have reviewed the text between Eric and Bryce.
I don't know. I don't know that this is a text from Bryce. I have no idea. This does not identify Bryce.
So
Doesn't
now that
identify anybody.
now that you have your memory refreshed, do you remember seeing this text between Eric and another individual saying that Corey and I are starting an open relationship tonight? Right?
It says, Corey and I are starting an open relationship tonight, so I told her I'm taking you home.
Right.
Yeah.
Okay. And you left that out of your report.
No. This would be part of my report.
Did you see sexting between Bryce and Eric when you looked at their texts?
I don't recall that, no.
Katie?
And is this sexting? I don't know what you mean.
No, I'm not talking about this one. I'm
Okay.
talking about other ones.
All right. I don't recall. I'm talking about many hundreds of thousands of messages in this case. I can't recall them all.
Do you remember seeing a whole bunch of emails like this or texts like this between Eric and Bryce?
Honestly, no, I don't remember. Like I say, there were hundreds of thousands of messages in this case. I don't remember even 1% of them. As I look at this, it just makes me laugh. It doesn't appear to be serious.
So how many of these joke sextings did you review that Eric did?
I don't understand this to be sexting. I think you're wrong about that. I resist your characterization. These are two friends joking with each other. That's what I'm reading here.
And they did that all the time,
I don't know.
hundreds of times?
If I had the records, and then I could answer your question, but I don't remember all of these messages. And yeah, this is a joke.
Did you review all of the texts between Bryce and Eric?
I think at one time I would have gone through every single text message that was available to me on Eric's cloned phone. So, do Do I recall it? Well, I recall that it was a bit mind-numbing. There was a lot there. Nothing particularly stuck out in my mind or memory about those messages.
Did they repeatedly talk about having sex acts together?
I don't recall.
Did they repeatedly talk about oral sex together?
I don't recall.
Did they talk about anal sex together?
Also don't recall.
But you read them all,
I'm sure that I did.
and it's all joking.
Knowing what I know about Bryce and Eric, yeah, that's how I interpret it.
So you do remember reading things of this nature, and you interpreted it all as joking?
No, as I sit here today, I interpret it that way. I would have interpreted it that way back at my original reading of it. That doesn't mean I recall it. It means I have an opinion about what I thought then. That's different.
And what did you think then? They were joking?
No. What I think now is that this was a joke. I do not have a recollection of this at the time that I first read it, but if I had a recollection of that time, I'm sure it would be the same as it is today.
And if there were these tens of 20s of 50s of these types of emails, all of them would be jokes?
Sustained.
That's it. That's all I have, Your Honor.
Ms. Nestor challenges Mr. Gabler's claim that he never saw any text about Corey and Eric Rickens having an open relationship and shows a few messages between Eric and Bryce. It seems that Ms. Nestor's strategy was to impeach Mr. Gabler with previous testimonies. Impeachment is the process of challenging a witness's credibility, which can be accomplished by attacking their character for truthfulness on the stand. Under Utah Rule of Evidence 608b, specific instances of a witness's conduct may be inquired into during cross-examination when two conditions are met. First, the inquiry must target the witness's own conduct and be raised during cross-examination rather than proved by extrinsic evidence. Second, the behavior must be highly probative of the witness's character for truthfulness or untruthfulness, such as a professional failure to document or report crucial case data. When these requirements are satisfied, the specific instances of conduct may be used to demonstrate that the witness is unreliable. Now, because Mr. Gabler claimed he could not recall any text messages regarding an open relationship and saw these texts as friends, playful banter between friends, Ms. Nestor did not reach the burden of proof to rely on Mr. Gabler testimony as untruthful. On March 16, 2026, Corey Rickens was found guilty on multiple felony counts, including aggravated murder, attempted aggravated murder, insurance fraud, and forgery. On May 13, 2026, a judge sentenced Corey Rickens, who received lifetime without parole. This case illustrates the critical importance of investigative protocols in civil proceedings and the impact they can cause in criminal trials. When a private investigator is involved in a civil proceeding and also becomes related to a criminal proceeding, the caution and the awareness of the investigation must be reinforced. By highlighting his methodology and explaining to the jury his process of investigation, Mr. Gabler ensured that he followed the proper procedures during the investigation. Even though he confirmed to move evidence, he corrected his mistake and put in his report to guarantee the chain of custody was properly authentic and keep the integrity of the criminal justice system. This case serves as a reminder that the integrity and reliability of a private investigator is not automatically guaranteed by his word, but for his truthfulness on the stand and his reports. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.